It is time for another installment of Martial Law with Marshall Chriswell this morning. This program intended to be for informational purposes only. The information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. And having said all that, I have just one of those fellows on the air with me now. Marshall Chriswell, good morning.
Good morning.
It's good to have you with us here today on this windy November day.
It's nice to be here no matter the weather.
There you go. Hey, we want to talk a little bit about something, a topic we visit fairly often, and it has to do with estate planning. And it's good to visit it often because there are so many different facets of it and aspects we need to explore. And one of those ones is one I want to get into today, and that has to do with who gets what you got. It's benefiting, or rather designating a beneficiary, and the various formats that has to occur, and the various things that we have to do in order to make sure that the people that we want to inherit our things when we're gone with this world actually are the people who get them. So can we explore that a little bit?
Absolutely, and that's a great topic because beneficiary designations are one of the most overlooked items when it comes to preparing an estate plan. So whenever we talk about beneficiary designations, normally what we're talking about are the people that you have designated to inherit your, say, a life insurance policy or a retirement account, a pension, certain brokerage accounts, even things like CDs and bank accounts that have transfer on death or in trust for designations on them. So all of these things are accounts that essentially you're creating as part of the contract that creates those accounts. You're creating beneficiaries, and you're saying, okay, when I'm gone, this entire account or whatever percentage I've designated goes to my spouse or my son or my sister or my friend. And so it's specifically designated who becomes the beneficiary of those accounts when you die.
Okay, so let's talk about some of those considerations that you're thinking of and the deliberations that go into it. Say it's a husband, wife, and one or two kids. Husband might figure that when I'm gone, she gets everything. Is that the case?
Right, and if you haven't set up a beneficiary designation, that very well may not be the case. So what we see with these beneficiary designations is that normally, they're associated with life insurance policies, retirement accounts that have been around for a very long time. Somebody, begins these accounts when, maybe when they first have a child or when they get their first job, or, so sometimes it's 20 or 30 years before someone even thinks about the beneficiary designation, and certainly what they intended back then isn't what they intend, to happen now in most cases. So one big problem, as I just alluded to, sometimes there are no beneficiaries set up at all, meaning that the account, whenever you don't have a beneficiary, generally what that account is going to do is fall to your probate estate, and that can cause big problems. Number one, as you mentioned, it may not all go to the surviving spouse. If, your probate estate doesn't necessarily transfer 100% to your surviving spouse when one spouse passes away. It's divided between a spouse and surviving children. Mm-hmm. That may cause a big problem. Yeah. So the beneficiary designation, really, when you're setting up your estate plan, one of the biggest things, and I think it's often overlooked, even by competent estate planning attorneys, to review with the clients what accounts have beneficiary designations associated with them and which ones do not. And the ones that do, let's make sure they're consistent with the plan.
Yeah, it only makes perfect sense when you get right down to it. Now, let's look at something like an IRA. An IRA with a husband and wife. He's got his, she's got hers. His name is on his, her name is on hers, and obviously there could be issues when one or the other of those goes with the surviving spouse, thinking that it's just going to transfer over to me.
Right. So if you've got your spouse set up as the beneficiary in the account, that's great. Just as with most of the time, we want spouses to be owning things jointly and reciprocal beneficiaries on these policies. But what happens when that second spouse passes away? And if there's no contingent beneficiary listed, so that's hugely important, is you need to have contingent beneficiaries listed on these accounts. Why do you want that? Because some people might be thinking, well, it doesn't matter. It's going to go to my estate, and my estate is going to go to my children, and it's going to go to them equally, and that's all fine with me. Well, consider this. In the event that you don't have a contingent beneficiary set up, the money goes into your probate estate, and you have creditors to your estate. When individuals or entities that have a claim against your estate when you die, and one of the most common types of a creditor is medical debt. Right, you incur a significant amount of medical or long-term care debt toward the latter years of your life, and then you have this. Let's just say it's $200,000, in an IRA or a brokerage account that all of a sudden becomes an estate asset. Now, because it is an estate asset, rather than passing according to a beneficiary designation, it is actually opened up for creditor claims. So, your beneficiaries could end up losing a whole lot of that money just because you didn't fill out a form to make them the designated beneficiary on the account.
Yes, and that can drain pretty quickly when you get to that situation.
Absolutely. And another one of the big issues with it is if you have beneficiaries set up that are not consistent with your estate plan. Okay, so let's say you have this life insurance policy. It's a $100,000 death benefit, and you set it up 20 years ago, and it was your children were maybe minors or hadn't even been born yet, and you made your sister the beneficiary of the policy. Okay, and then you want your children to inherit your entire estate equally, but you never think about that beneficiary designation. So now your estate is being distributed in a way that you didn't intend. Or if you just have one child as a beneficiary on an insurance policy or retirement account or what have you, then that child ends up getting a larger share of your net estate than they otherwise would have. So again, it's really important to make sure these beneficiary designations are consistent with the plan, because no matter what I write into your will or I write into your trust, however I do that, I cannot control by those documents alone the way that those beneficiary designations transfer those assets. They will supersede any other legal work that I do to create your estate plan. So they really have to be considered.
Okay, so this brings into question a whole different set of things that must be done that I have to check off the list as those retirement years and the years afterward progress, because you're right. Grandchildren might come into the picture that weren't even around when you made your original designations. So take me through the process. What would happen to somebody who would come to you, for instance, and say, Marshall, I heard you on Indiana in the Morning the other day talking about beneficiary designation. I'm not certain exactly what you mean by it, but I need to know more, and I need you to fill it in for me.
Well, the first step is to have a detailed conversation about what your goals are, because that's what drives everything that we do. Is who are the people in your life? What does your family situation look like? Who are the intended beneficiaries of your estate? And what are your concerns? Is it taxes, or is there certain creditors that you have concerns about? Are there family issues that you have concerns about? People don't get along, or one beneficiary needs more than it has greater needs than another. However it is, we've got to have a detailed conversation about what your goals are, and from there, then we build the plan. And part of that, of course, is looking at those beneficiary designations and making sure, for example, if you have children who are minors, or you have even adult children or other beneficiaries who have special needs, then it's going to be a much different conversation than somebody with a different situation. And looking at those beneficiary designations, I mean, you really don't want to set those up so that minor children or individuals with special needs would be inheriting directly through the beneficiary designation. You'd want to have some trust provisions set up, and those can be built into the estate plan, and then the beneficiary designation flow into that trust. So it's a matter of really digging into what's your situation and what are your goals.
So down through the years, you and I have talked here on this segment here on Indiana in the Morning, and we have emphasized that Marshall uses pen and ink. He doesn't use chisel and stone. And therefore, it's always good to not only set something up, but then to revisit that after a period of time in order to make sure everything is according to your wishes. And I would assume that that's the case here, too.
Yeah, most people have circumstances that change over time, right? Children grow up, people unfortunately pass away, family relationships change, and so it is hugely important that at least, in my opinion, at least once every 3 years, if there's a major change, obviously you want to think about it sooner, but at least once every 3 years, let's get those documents out of the file. Take a look at it. Give me a call, and we just have a brief conversation that I don't charge anything for, to say, all right, is everything still appropriate here? Have there been any changes in the law that might affect my situation? Because that happens often. Mm-hmm. And just go through it quick and just say, okay, maybe this is the year that we need to sit down and have a conversation. So these documents, by and large, estate planning documents are always modifiable, and it's something that you should think about over time.
Now, it's interesting you said that because I was going to ask you, are there statutory considerations that come into play because of changing laws, and they can be pretty radical at times, and so we should keep abreast of that as well, or you do, I know, in your position.
That's absolutely right. I mean, these laws and people, if you're not involved in it, you don't understand. But the laws surrounding these issues change on almost an annual basis in some form or another. And it doesn't always mean that it's changed so radically that, you have to create new documents. But, there are issues. This year the legislature passed a new statute, and we actually did a segment on this earlier this year, on digital assets, right? And does your executor and your powers of attorney, what needs to be in the documents to give them the ability to access things like online bank accounts or cloud-stored videos and photos and emails and social media accounts. All that stuff is rapidly changing. So it's changes that it's beneficial to make some edits to the estate plan when those things change, if they affect you, and it's a conversation we want to have.
All right, absolutely. So if somebody wants to have that conversation with you, what must they do?
Can give me a call at 724-465-5826. Stop and see us in the R&P Cole building at 655 Church Street in Indiana, or go online to www.westernpalawyer.com.
Marshall Chriswell, thanks so much.
Hey, thanks a lot, Todd. Take care.
You too. We'll see you. You too. We'll see you. You too.